Good morning, Mr. Lundgren.
Good morning, Your Honor. If it please the Court, my name is William J. Lundgren, and I represent the Salem Contributory Retirement Board. This is a case of rather straightforward facts, which I do not believe are in question. And a Secretary Administrative Assistant in the Department of Public Works for the City of Salem towards the end of the day was called into the Director of Public Works office and informed that the budget that would be coming down eliminated her position. And that budget would not have taken place for 5 or 6 months, and he was letting her know this so that she could have an opportunity to look for another job. She became upset, went home, and approximately an hour later had a heart attack.
Can I just ask you a practical question?
Yes.
Since she died in 2003 or somewhere in this process, and these are disability retirement benefits, so
Yes.
The impact of this is what?
The impact to Ms. Cole is nothing because she's
Obviously.
passed away.
Right.
The impact is to the system, because my understanding of the rulings of this court, beginning with the Bonafuldi case in 1958, is very clear that the personal injury has to be in performance of the job.
No, just as a practical matter, let's assume, just so I can find the answer, let's assume that she wins, or is this money that goes to her estate, or what
If
what
she
happens?
wins, there would be a small amount of money that would go to her estate. In fact, I think the amount would be $40,000.
Okay, so that's what's at issue,
That-
in
well,
dollars
that's-
and cents. I understand there's principles at issue, but that's what's at issue in terms of
The
dollars.
dollar amount, in my understanding, is approximately $40,000.
Okay.
However, the impact of the system, to me, would be that you would have to change the long-standing rule in interpreting what is an accidental disability. And if
As
you-
I understand, there are two disability types of forms of retirement, are there not? There's a regular disability form and an accidental disability form.
Yes, Your Honor. The accidental disability is 72% tax-free for life, and if you die from that event, then the 72% tax-free to the surviving spouse.
Well, was this a personal injury?
Was this a personal injury?
Yeah.
In my opinion, it wasn't. But even if it was not. Even if it was a personal injury, it was not sustained in the performance of her job. And I think where we're getting confused here is that if the Superior Court had strictly applied the guidelines that have been set forth by this court, the issue would have been when she was confronted with the news of her job being eliminated, was that in the performance of her job? And if you look at the Namvar case, which was where the professor was walking back on campus from lunch to her office, didn't get to her office, had an accident, the court said that that did not take place in the performance of her job.
But could I ask you a question? Because there are two cases I just wanted to ask you about. One of them is Richard against the Retirement Board of Worcester, and the language is, while in the performance of duties reflects the legislature's intention to limit accidental disability retirement benefits to claimants whose injuries result from the actual performance of their job duties. So in this case, I mean, isn't there a very strong argument that the injuries, that is the heart attack, resulted from listening to this fact that she was going to be terminated?
Yes, that's the trap, because this statute says in the performance of her duties. The workers' compensation statute would, in your case, as a result of...
No, I'm reading you while in the performance of duties. This language is from our court interpreting the language that you're talking about.
I'm not familiar with that case. The most recent case that I'm familiar with is the Namvar case, and that was further followed by the Damiano case in the appeals court, where the lady was a dispatcher and got up from her desk to go to the ladies' room and get supplies to bring back to her job as dispatcher. an altercation took place and she was injured, and the appeals court, following your decision, said she was not injured in the performance of her duty as a dispatcher. And I think the danger here is what happened in this case is everybody looked and said, well, this is a personnel action, and looked to the workers' compensation statute, which provides that personnel actions, it doesn't cover physical injuries. It only covers emotional injuries. And they said, well, this is a personnel action. An event took place. She subsequently had a heart attack. It's therefore not covered by the personnel exemption, and she's entitled to accidental disability. I don't believe that's a correct application of in the performance of her duties. I mean, did this event take place while she was at work? Yes, it did. But in all of the cases that I have read from this court, it has to be something more than an injury that took place while she was at work. It had to be in the performance of her duty. And so if you decide at this stage that
So are you saying that listening to her supervisor tell her she's going to be terminated isn't in the performance? Is that what you're saying?
that's exactly what I'm saying. And if you applied your theory,
But if she didn't have a job, that wouldn't have happened.
well, that's true. But
So isn't the job the sine qua non?
I mean, if she's
well, her job, the sine qua non of her job was as a secretary and as an administrative assistant. It was not,
if a supervisor
But now she doesn't
talks-
have, tells her she doesn't have this job.
well,
Isn't that part
yes,
of?
but the incident where she is in his office and he is engaging in a personnel action, as I read the cases, is not in the performance of her job. It would be the same if you had a firefighter.
She had to go in there because he was her supervisor.
Again, if you look at the cases that have been decided, the professor that was walking back from lunch to get to her office to teach on campus was injured, was not in the performance of her
But
job.
that's different. She didn't have to go to lunch. She was off campus, I assume, going to lunch. This woman, part of her job was reporting to this man, and if he says, come in here, I'm going to give you an assignment or tell you something, she has to go in there.
Well, he asked her to come in as to help her get a job, knowing that her job was being eliminated.
Well, what if she said, no, I'm not going in to talk to you?
Well, he would have probably at her desk said, fine, your job is being eliminated. But as
Can I-
I
can I-
understand the as I
And
understand,
then would she be covered in your theory? She's sitting at her desk? and he
no,
comes-
because she is not in the performance of her job. I mean, you can go ahead and say that you will expand the definition of in the performance of your job. And if you do, that means anything that you're doing while you're working. A firefighter on duty could be called into the chief's office and told that his job was being eliminated. Now, if you would therefore be saying that that is in the performance of his duty.
Isn't there a special statute dealing with firefighters?
Yes, there is, and I bring that up only because in I think it was the Namavar case, they say it's easy for you to say in the performance of your duty if you're a firefighter. You're going into a building.
Sure.
And you get burned, you're a police officer, you get hit while directing traffic.
Well, let me ask you, so she's at her desk, and some terrifying thing happens at work. Gunman comes in, shoots somebody. She's got this heart condition. This causes a heart attack. Not when she's on the job site, but when she goes home. Same case, different case?
I would say, in my opinion, that does not entitle her to accidental disability.
Okay.
Would she
Ceiling
be-
collapses right next to her desk. It's terrifying. But because of her specific condition, it causes a heart attack when she comes home. Again, not in the performance
I
of her
would say
duty.
not in the performance of the duty. As I
So
read
if
the
typewriter
case.
falls on her,
If the computer exploded and she was injured, that's in the performance of her duty. If she gets up to go to the ladies' room and she trips and she falls,
all right, so computer explodes but doesn't cause any physical injury. It just explodes or catches on fire or whatever it does. But that causes a shock to her system. She goes home, she has a heart attack. That would be covered. That would be in the performance or not.
well, I suppose you'd have to have somebody, the doctor, say that that is what in fact
Causation.
caused the heart attack.
Sure. But is causation an issue here? I sort of read your brief to suggest that it was an issue, or no?
Yes.
I do not believe causation is an issue, because I cannot
So that
get-
means you're satisfied that there's causation between what happened at work and the heart attack?
Well, the doctor said that there is.
Okay.
Okay, but I don't, again, I think what everybody is looking at is they're not looking at what is the definition of in the performance of your duty.
Okay.
I mean, all of these cases that you cite, I mean, would the person be entitled to workers' compensation benefits? Absolutely.
Okay.
I mean, that's not an issue. I mean,
All right.
the issue is how
Fair enough.
far are you going to expand what has already been decided on in the performance of duty? And if you do, then I notice in the call for amicus briefs that you want to know what the impact on the system would be. Well, the impact on the system would be that those people that under your current rule are not entitled to accidental disability would be entitled to accidental disability. What would be the distinction then between Chapter 32 and Chapter 152?
Is she entitled, or would her estate be entitled to a different kind of disability benefit?
When she retired, she would have been entitled to disability benefits, but the disability benefits wouldn't have been much different than the superannuation.
But they're not, it's not the accidental disability
It's not
benefit.
the accidental disability.
Wasn't your argument, Mr. Lundgren, in the brief, and maybe I didn't read it right, but I thought it was that the injury that happened on site was an emotional injury. Therefore, and it fit within the language about bona fide job action because she was being terminated. And so it wouldn't be covered as a personal injury, as Justice Ireland was asking. And that although the heart attack happened later, there wasn't a causal connection.
My position is that what happened in the office was an emotional injury.
Right.
And that is specifically excluded in the personnel exemption.
So it isn't that it was, but the argument you're making today, it seems to me, is, yes, the injury was a personal injury, but it wasn't in the course of her duties, which is a different...
And I thought I'd made that in my brief, is that we're going, there's two separate tracks here. And what the Superior Court started off on was going down this, well, this is a personnel action. And if it's a personnel action, it was a physical injury because the doctor connected it, and therefore it's exempt from the personnel statute. That's how they get to the award of the accidental disabilities. And what I'm saying, we shouldn't even be discussing this. I mean, what we should be looking at is, in fact, what happened that day, was it in the performance of her duties?
If the supervisor had waited until the workday ended and called her into his office and explained this, would she have been entitled to a disability benefit?
I don't know. I would think she would be entitled to a disability benefit because the only requirement for a disability benefit is that
You're
you are
disabled.
disabled. And I think at that point she would be.
So you're saying this kind of notification, the fact that it occurred during work hours really is not determinative. She could have received a letter at home stating exactly the same thing, and it would have not been work-related.
Again, we're moving off, and we're not applying the standard that has been applied since 1958. When this originally started out, before 58, it had to be an accident. And then the statute was amended to say personal injury. And then when the first case came up to the SJC, they narrowly interpreted personal injury in the performance of one's job. And that case, in fact, the last time the court issued it is that, this, I'm not sure they were happy with it, but the consistency of treatment it provides fairness among employers. And if the legislature wants to change this standard, personal injury as a result of and in the performance of one's duties, if they want to change that standard, fine. Now, for the court to change that standard and say a personnel action is in the performance of one's duties, that's the decision that has to be made today. I'm saying that a personnel action and any other issues that you may be doing during the day, if it is not in the narrow performance of your duties, does not give rise to an accidental disability pension.
Thank you, Mr. Lansgen. Mr. Applebaum?
Thank you, Your Honor.
Mr. Applebaum, what if the supervisor had sent her a letter at home communicating exactly the same information and she had died of a heart attack? Would she be entitled to an accidental disability?
In my opinion, she would be, because it's a work-related matter, and I think if you look to the workers' compensation statute.
But we're not talking about, I mean, I know we look to the workers' compensation statute.
Right.
I don't mean to interrupt you, but
Oh, that's fine.
I mean, if you look at Chapter 32, I mean, the purpose is, I mean, this is unusual, because leaving aside that it's a personnel action, you know, whether or not she had to attend the meeting with the personnel director. What this is any member in service who is unable to perform the essential duties. In other words, the sine qua non of this is that this is somebody who's going to be able to, who should be continuing to work, but is unable to do that. Here you have a situation where, in any event, she wasn't going to be able to continue to work. I mean, it's a rather peculiar set of circumstances here.
Well,
I mean, if you look at what the legislature is trying to do, the legislature is trying to assist employees, ongoing employees, no question that they will continue to work, and then because of an injury that occurs while in the performance, not in relation to it, but actually while in the performance, they shall be retired for accidental disability. She wasn't going to be retired.
well, that's a very close question, I would guess, Your Honor, if that's what you're saying, is that because she was not actually typing, because she was not actually delivering, doing filing at the time?
No, I'm going to a slightly different point, which is what the legislature, I think, was trying to accomplish here, which was to say people where the presumption is that you were an ongoing employee, but you are not able to perform your work. She wasn't an ongoing employee.
At the time when she was told that she would be terminated, I suggest she was.
I mean, she was an employee, but the whole point of this was that she wasn't going to be continuing as an employee.
Well, but that was going to be 5 or 6 months down the road, Your Honor. She was going to continue with her job, and the position was going to be...
But the whole point of this is that this will be for the remainder of her life. It so happens in this particular case that she didn't live for very long, but you could have a situation where somebody who was not going to be an employee, you know, is essentially remains, as it were, a lifelong employee.
Well, I suggest that might be somewhat speculative in that what if within that 6-month period there was funds allocated to allow her to go back to continue on with her job? I mean, I don't know whether that would be something that would be possible, but it seems to be it'd be speculative to say that because the job would be terminated as of 6 months down the road that she's doesn't qualify at the time.
I understand.
How would the workers' comp statute apply here?
The workers' comp statute defines personal injury as a disability stemming from a single work-related event or series of events, and also goes to the personnel exception.
Well, essentially what was happening in the workers' comp thing, which is a little different from here, is to get workers' compensation benefits. It seemed to me that the legislature was trying to deal with those situations where there wasn't a physical injury. You know, there was a claim of stress or sleeplessness or could be quite serious mental emotional disability, and the legislature essentially said those aren't going to be covered unless this is deemed an intentional infliction of emotional harm.
Which is not our case here.
Which is not the case, and you can understand that. Somebody who is deliberately doing, a supervisor deliberately doing, but if somebody comes in and says, as a result of this conduct, I haven't been able to sleep, I've had medical conditions and so on. The legislature said, no, this is essentially physical.
I guess the point I was getting at, though, maybe I'm misunderstanding here. Would this employee have been eligible for workers' compensation benefits, assuming this was a physical injury, as the court found?
Yes, it would be a question of medical evidence as to whether, as in this case,
Causation?
as the panel found causation.
So the question here is, well, I'm sorry, go ahead.
Got a hypothetical for you. I just want to see if I understand in the performance of your duty. So let's say I'm driving my car and but I'm thinking about some of the cases that are scheduled here at the court. And they're very complicated and they give me a headache and I have some kind of medical problem. Is that in the performance of my duty?
I would suggest not, Your Honor. After you leave this honorable court.
Well, there's good.
I have to be at the courthouse?
It's a coming and going rule.
Right, coming and going.
I mean, so that.
Correct, Your Honor. There is the rule says once you've left and
So to take, just following up on that and Justice Spina's question, if she were actually at home and got the call from the supervisor who says, I didn't get a chance to tell you today, but I need to tell you now that as of July 1, we're reorganizing the department and there will be no job for you.
Well,
why would that be different?
because that's involuntary. She wasn't
But I
thinking
let her
about the
through the mail.
cases. That's something, she gets a phone call from a supervisor.
But she's not, she's making dinner. I mean, she's not performing her duties as the secretary in the water department.
I don't want to have to be in a position of trying to defend that scenario, Your Honor. I'm not really sure how that would come out if this court would address those specific facts, but
that is the heart of Mr. Lunzelgen's point. That is really the essence of his argument.
well, unless I don't understand it, the distinction here is that she's on the site, she's at the job, she's actually performing the job duties until the time when she's called into the office to be told that her position will be terminated down the road. Also, regarding the Namvar case, in that case, which my brother's relying upon, it talks about a woman going to lunch, which is not at the time of work, not on the job, and then going to her job, and that's a very...
That's closer to the coming and going rule.
Correct, Your Honor.
Yeah.
I mean, there's been a lot of litigation over the coming and going rule, so to some extent we can just leave the coming and going rule, at least from my point of view, somewhat aside, because there's been so much litigation about whether somebody was instructed to go, maybe in the Amvar case she wasn't instructed to go to lunch, but what about the visiting nurse who's instructed to, I mean, there's a lot of litigation, as you know. So this is somewhat different. You're saying, I mean, the nature of her work was.
She was an assistant. She was an administrative assistant, Your Honor.
Right. So if you looked at her job performance, if you looked at the description, I think this is Mr. Lunzelgen's point. If you looked at the job description, whatever it involved, if it was filing. I take it he would say that if she opened the file cabinet and saw a rat, and the rat caused her to have a, to get an enormous fright, and that triggered a heart attack, I think, and I'm not asking him to agree, but I think Mr. Lunzelgen would say, yes, that's in the performance of her job. The performance of her job was not receiving notice of termination from a personnel director. That's not the performance of her job. That's his point.
I understand the distinction, Your Honor.
Sure.
I'm just suggesting it seems to be very close, and she would not be in that position had she not been employed. She would not be in a position to be told that she was...
Mr. Applebaum, if I can return to a question that Justice Botsford started off with, as I understand the importance of the issue, I mean, beyond whatever compensation her estate, your client's estate receives, this seems to me to be a very unusual fact-specific case.
It is, Your Honor.
So let me ask you this. If we were to agree with you, and I'll ask it, do you see a broad impact? In other words, let's say, for example, think of every other job description. other than firefighters, but let's say somebody's job it is to clean the building, right? And no question you can be damaged while you're cleaning a building. And then on a particular day, the building supervisor calls you in and says, we're terminating your job, maybe because we're outsourcing it or because we're downsizing, whatever it is. Is this going to be a big impact decision if we say that's in the performance of your duties?
I don't see that as happening. Even Judge Billings made reference to that in his initial Superior Court decision. This is one of very few cases of this type.
But why is it any different than if the supervisor called her into the office and said, you know, Claire, I have very bad news for you. Your brother just died. And she has a heart attack and drops dead. Why is it any different than that?
Well, I'd suggest it's because she's being told that her job is being terminated as opposed to being told that her brother had died. But again, I'm also suggesting because it's happening at the job site. Now, in that scenario, I suggest that may not be compensable. Maybe that would not allow her to recover if it was a relative who died, and that's the information she receives. But I can't say for sure.
Well, wouldn't Justice Spina's, wouldn't the distinction there be that it wouldn't be a personnel action?
I understand. Well, that would not be a personnel.
So then you wouldn't get into that question of whether it was a personnel action.
That's correct. And also, you're talking about the medical panel, which has to make the final determination, if you will, as to causal relationship, and then adopted by the agency, by CRAB. So you have quite a few hurdles to get through to say that you've had a disabling heart attack based upon some information you've received on the job. Pardon me. No water.
Perhaps the court officer could bring some water. Mr. Applebaum, do you have any further points?
No, Your Honor, I'd rely upon my brief.
Thank you, Mr. Applebaum. We'll take a short break.